I'm assigned to slides 15 through 30, and in essence about 15 to 18 minutes to cover the waterfront of what's hot and what's not, and what's new and what's not in terms of workplace class actions and bet the company cases. And so what I'm going to try and do is focus on 5 trends. They're on slide 16. And I call these the drivers of the dynamics of litigation that employers are facing throughout the United States. I wanted to give a shout out today to my class of students at Northwestern University, where I'm a professor of law, where I've spoke for 25 years. One of the things we typically talk about in our class when we read about cases in our law books is the disinclination of companies to become part of legal history, to be known as the, quote, case, end quote. And so one of the things in my goal today when I speak with you about what's new in the workplace class action world, it's focused on helping employers not become what's known as the case that law students think about and read about and what judges are citing in their opinions, but rather to think about ways to bulletproof one's HR practices to make our workplaces even more compliant in the future, and to lessen your litigation risks in terms of these bet the company cases. So with that, maybe the next slide, and I wanted to speak on the first trend, which is what the United States Supreme Court did this past year. Brandon gave a great summary of those key cases, but having followed this area for 15 years and now written over 14,000 summaries of decisions, I think probably there are 2 cases in the last 15 years that outweigh and are more important than any other cases. The first was in 2011, the famous Walmart Stores v. Dukes case, and until this year, the second most important was probably the Comcast case. And those were 2 decisions that created impairments or impediments to plaintiffs trying to sue companies and trying to certify these huge cases. And that was until this year when the Supreme Court decided the Epic Systems case. And in my way of thinking, that's probably now the most important, or maybe tied for first place with Walmart Stores v. Dukes, because Epic completely changes the dynamics of the playing field in federal court. When I go into court and defend our clients, and I'm armed with arguments based on the Epic Systems case, that is a game changer. And what we've seen in the latter part of 2018, coming into 2019, is class action litigation will never be the same again on account of the Epic Systems case. There's certainly the intellectual analysis of what the case says and the reasons behind it, but the practical impact of that case in terms of how it changes the way in which cases are configured, how they're litigated, how they're brought, how they're defended, how they're disposed of is bar none different in kind than any other Supreme Court case. So I think one of the takeaways in the Supreme Court, given that that decision was 5-4, is what a difference one person can make in terms of the nomination of someone to be on the Supreme Court and to be in a position to make a decision that can impact all companies, all workers throughout the United States. And there's a great example where one vote in a 5-4 vote changed the way in which class action litigation is litigated and defended and prosecuted forever. There's been a lot of talk about a legislative response to Epic Systems. In my way of thinking, it's not going to occur until there's a different party in the White House or a different party has complete control of the House and the Senate. It wouldn't be the first time that the United States Congress passed a bill to undo decisions rendered by the U.S. Supreme Court that occurred in 1991 when the Civil Rights Act of 1991 overturned about 8 Supreme Court cases that had adjudicated issues under Title VII. So I think that Epic Systems may even make its way into the presidential debates in the next round of elections because the stakes are so high and the interests that are implicated are so pervasive. So by my way of thinking, and I think Brandon would agree, that was far and away one of the most significant trendsetters in terms of the dynamics of litigation. Next slide, please. I tend to view, and when I teach at Northwestern, I'm an advocate of the position that one way to view Supreme Court cases is from the viewpoint of, does it open the courthouse doors wider and invite litigants into the courthouse to bring their cases or litigate their claims, or does that decision close the courthouse doors and make it more difficult to either file the claim or litigate the claim, or easier to defend it? And so one way to view the major decisions of the Supreme Court in 2018 is from the vantage point of door opening or door closing. And I think people would have to agree that this was a term where the Supreme Court closed the door, narrowed the door, made it more difficult for class action plaintiffs to litigate their claims. Braden had mentioned the Encino Motors case in construing exemptions to the Fair Labor Standards Act. From a practical standpoint, what it means is more workers will have less viable claims and more employers will be able to dispose of those claims than ever before, because the Supreme Court reversed the thinking that those exemptions should always be broadly construed, because the public policy of the Fair Labor Standards Act, signed by Franklin Roosevelt during the New Deal, was designed to err on the side of workers. But the Supreme Court's decision reversed that trend, narrowed those exemptions, so I think has to be viewed as a door closer. The Janus case that Brandon had mentioned has the practical impact, not so much into class litigation, but to close some doors in terms of the ability of public sector labor unions to broaden their membership, so it's a pro-business decision. The China Agritech decision, although it deals with a very technical, arcane, nuanced issue of tolling, a lawyer's term for a delay pattern in a case and allowing someone to file a second or third or fourth class action after the first one was dismissed, that door has been closed off. In essence, there's one opportunity, one bite at the apple for litigants to bring these claims, and there won't be a second bite at the apple. And then finally, the Jesner case, probably a sleeper decision from 2018, in essence said, the business of American plaintiffs' bar suing corporations in United States courts for alleged human rights abuses in foreign countries no longer will take place. U.S. courts won't have jurisdiction to hear those cases. Those cases should be litigated where they arise, in India, Cambodia, Chile, wherever, and U.S. courts will not entertain those class actions. So in terms of the United States Supreme Court and the trend and the impact of the Supreme Court, it basically made class action litigation more fraught with danger for the plaintiff side, made those cases a bit easier to defend on the employer side or the defense side, and had the impact in your mind's eye of closing the courthouse door a bit in this particular area. So very, very significant trend in terms of its impact on corporate America and the American people. Next slide. Trend two is our data analytics trend in terms of actually viewing every single day and grading and putting into categories class certification rulings throughout the United States everywhere, and basically putting it on a graph and being able to show our readers what these decisions mean. And not unlike real estate, one of the takeaways from those analytics are location is an incredible driver of litigation results, and that the same case often might be decided in a different manner depending on what judge one is before and what judicial circuit that judge sits in, because the case law in the various circuits differ in the ability of the plaintiff's bar to secure certification, or the ability of an employer to block certification and to cut the roots of one of these big bet the company cases, in large part turns on location. There's a reference on slide 19 to the Second and Ninth Circuit. The Second Circuit's along the Atlantic Seaboard, Metro New York. The Ninth Circuit in California on the left coast, so to speak, based in San Francisco, and well known among the plaintiff's bar that those are the most plaintiff-friendly jurisdictions with the lowest sort of standards to certify a case. Major corporations in America do business in those jurisdictions. More often than not are sued there. So quite a bit of litigation involving bet the company cases in those areas. And these analytics bear out the common feeling among employers that those are jurisdictions that tend to be more favorable for plaintiffs and less favorable for defendants. But there's also some silver lining in the clouds in terms of what these analytics show. The slide 20 demonstrates the volume of wage and hour litigation filed since 2012. We've tracked those numbers, and those numbers exist quite a few years back. And what it would have shown had we expanded the slide is from about 1995 to 2015, every single year, like death and taxes and certainty, there were more wage and hour class and collective actions filed than the year before. We kept waiting for the wave to crest, but it would never crest until the year 2016. And in 2018, we've now had the third year in a row of declining numbers of these cases. But in speaking with general counsel and business executives about what keeps them up at night, there is no doubt but that wage and hour issues, the manner in which people are paid and compensated, is the #1 corporate exposure for employers in the United States, and it's the exposure that generates more class action and collective action litigation than in any other area. And although there has been a declining number of these cases over the last 3 years, the court system is still chock full with these cases, and because of the high majority of these cases involving class and collective action issues, there are more rulings, there's more case law in this area than in any other area. Add to that the Department of Labor bringing government enforcement actions. It's a perfect storm that aligns with this is the area where employers, where risk meets the rubber of the road, where the most cases are brought and where the most litigation happens. Unlike other areas, there's a very low entry bar to get into the area, so good plaintiffs' lawyers migrating to this area year after year. One of the what-ifs and one of the unknowns for 2019 will be the impact of Epic Systems and whether or not that will depress these numbers more, such that in our book launch event next year, whether or not we're going to see a fourth year of declining numbers and whether or not there'll be less cases filed again. But this is a very, very significant trend for employers for 2018. Next slide, page 21, maps out the certification numbers in terms of the areas of the country. The United States map has those numbers, and it used to be that the Second and Ninth Circuit outweighed and had more decisions than the rest of the country. And what we saw in 2018 for the first time was Mid-America, the Fifth Circuit based down in the Southwest, the Sixth Circuit in the Midwest, and the 11th Circuit in the Atlantic Seaboard in the Southeast also spiked and generated more wage and hour cases than in any other time and began to become a little more plaintiff friendly. So the pockets of vulnerability, so to speak, are expanding in the United States in terms of where skilled plaintiffs, class action lawyers are filing their cases. Our last analytic slide is slide 22, where we've charted out odds of success, what the analytics showed us in terms of the rulings in 2018. And what it showed is if you were an employer sued in a wage and hour case, you lost 4 out of 5 times, 79%. If you see that bar graph on the left-hand side of that slide and compare it to the right-hand slide, you'll see that 79% was the highest conversion rate or certification rate that the plaintiff's bar has ever enjoyed in the United States since these analytics have been kept, and also is a driver and shows why wage and hour exposures are the area where the plaintiff's bar focuses, because they have the most success. If you then look at what is called the decertification phase, employers were successful in a jump ball situation about 52% of the time. And where settlements occur is between that 79% number and 52% number. Plaintiffs' lawyers know that if they can certify the case, it will cost the company an arm and a leg to defend that through the discovery process, involve hundreds, if not thousands, of people. Some employers, however, gird themselves, go through that process, and what the case law showed was about 52% of the time, half the time, they were successful in decertifying the case, fracturing it, and getting rid of it. So this is kind of where the rubber meets the road for corporate America in terms of either spending or saving money. Again, with Epic systems being overlaid on top of that, it will be interesting to see as 2019 plays out how those statistics may fortify or change in terms of the amount of certifications that occur. The last trend 2 slide, slide 23, shows what occurred in the other areas that we track, employment discrimination. And there, the plaintiff's bar, hardly successful, 1 out of 4 times, 27%. I think that goes back to my observation about the Walmart Stores v. Dukes case, decided back in 2011, raising the bar, making it more difficult for plaintiffs to certify their case. And so basically employers are winning 3 out of 4 of those cases and preventing them from becoming huge corporate risks. That's a pretty good batting average, pretty good percentage in the employment discrimination area, and as a result, less and less of those cases are being brought. I think that's indicative of kind of the stock market approach of the plaintiff's bar to bringing these cases. Am I going to get much of a return for my investment of time and effort? Obviously, in the employment discrimination area, where they're only successful 27% of the time, the faint of heart, as Tracy had referred to, probably aren't spending more of their time and money in that area because of the lack of return. If you flip over to the ERISA side, the litigation of employee benefit or retirement programs, plaintiffs doing a little bit better, 65%, still not even close to their success rate in the wage and hour space. And I think indicative there is that the Dukes v. Walmart concepts have taken hold in part in the ERISA arena. They have not taken hold at all in the wage and hour area. So in terms of this three-headed monster, the 3 main exposures to corporate America, you see that wage and hour is still kind of the snapping turtle, the difficult area where the plaintiff's bar is concentrating, not so much so in the employment discrimination area, and kind of flat in the ERISA area. So I think that that's a very valuable kind of tour of those analytics of what that tells you about 2018. My personal prediction is those numbers are going to change because of Epic systems. They're going to stay or go down in the employment discrimination area. I think they go down in the wage and hour area. I think they go down or they remain flat in the ERISA area. Trend 3. Trend three, I think, is one of the most interesting and maybe most counterintuitive trends, and that is the government enforcement litigation programs that employers face. And we're looking about lawsuits brought by either the United States Equal Employment Opportunity Commission, which has authority to police the workplace in terms of employment discrimination statutes, or the Department of Labor that can bring wage and hour and ERISA cases. And despite the existence of a proclaimed business-friendly White House and a president that wants to increase hiring, increase employment, grow our economy, his EEOC brought more cases fourfold as compared to the last year of the Obama administration. If nothing else, the EEOC is still an aggressive activist agency filing a multitude of lawsuits, so much so that employers have to take into account the risks of doing business in terms of EEOC and Department of Labor investigations. I've always told clients that defending a lawsuit brought by the EEOC is not unlike holding a tiger by the tail. It's a very, very difficult proposition when the full weight of the United States government comes down on an employer with an unlimited budget to do what it wants, to be able to shake that company upside down and try to expose any alleged discriminatory practices, and tend to be very, very difficult lawsuits to defend, given that the government sues in the public interest, and the monetary awards that a private plaintiff's attorney might be interested in to view that as an economic proposition fall by the wayside when dealing with government enforcement lawyers who are litigating in the public interest. So I think I've been asked at various times, why is this happening, and why, with a business-friendly president, why would these government agencies be more active? And I think there are a multitude of explanations for it. But one of the reasons is there are many, many things going on in Washington, D.C., and who is running the Department of Labor, the EEOC, and their complement of leadership probably is not as high on the agenda as other issues. And so what occurred in 2018 insofar as the EEOC was concerned is the president nominated new leadership, nominated a new general counsel. Presumably they had a more business-friendly mindset, or a mindset not aligned with the way the Obama EEOC had litigated or enforced the law, but the Senate never passed upon and never voted on those nominees, and they expired. So the EEOC leadership has been running at less than a full complement, and as a result, career government enforcement lawyers in the field, unchecked, unrestrained, having the ability to do what they want to do without contrary instructions from Washington, D.C., filed more lawsuits in 2018 than had been filed during the last year or all the years of the Obama administration. So a very ironic, somewhat counterintuitive view of what government enforcement litigation is all about and what occurred. Next slide, please. On slide 25, we dissected, as we do every year, each of the lawsuits filed by the EEOC. And what you would see is that basically most corporations are apt to be sued for one of two things, either gender discrimination or disability discrimination, by and large, compose the docket brought by the EEOC. But probably not unlike college students have discovered in speeding through Florida towns on the way to Fort Lauderdale for summer vacation, there somewhat looks to be like a quota system whereby a high majority of the cases are filed in the last month of the fiscal year. 45 cases were filed by the EEOC on the last day of its fiscal year, and 84, a high majority of its lawsuits, were filed in the last month. It has been publicly expressed that there is no quota, that people don't look at those numbers, but year after year, and certainly in 2018, we saw a high majority filed in the last month, if not the last day. So a very interesting kind of inside view in terms of what's been going on with the government. Next slide, please. In terms of the media reports on our workplace class action report, Trend 4 was one of the areas that the media focused on. I know, Braden, you and your colleagues thought that this was a very significant marker of class action litigation in 2018 in terms of the value of settlements falling through the proverbial floor by the tune of $1.4 billion. What we do is on a daily basis track every settlement in federal and state court in one of 5 categories, either employment discrimination, wage and hour, ERISA, government enforcement litigation, or statutory employment law claims such as workplace antitrust or Fair Credit Reporting Act claims. And we add up the top 10 largest settlements in each of those areas. And last year that totaled the $1.32 billion and was the largest drop from year to year we've ever seen in 15 years. And I think that one way in which to view those numbers is Dukes v. Walmart, which created the higher barriers to certify a case, which is the same way as saying monetizing a case, along with the defenses that employers could invoke based on the Epic Systems case to keep cases out of the courthouse, to force them into arbitration on an individual basis, took hold and had the impact of employers being able to face down these multi-gajillion-dollar demands and settle cases for significantly lower dollars as compared to past years. My prognostication for 2019 is that settlement values, more likely than not, will go down again because of those twin pillars that the defense bar and employers can invoke to defend themselves in these sorts of cases. Next slide, please. Page 27 broke down the areas in those 5 categories, and no category was up. All 5 categories were down. The biggest decrease was in the ERISA area, over $614 million. Also, government enforcement settlement numbers fell through the floor, more so than any other year. So although the EEOC filed more lawsuits in terms of monetizing those lawsuits and settling them, they did so at lower numbers. So I think this is an area that will be watched. This is good news for employers. I think this trend probably will hold. The last slide I wanted to share was on page 28 with wage and hour settlements, and you'll see a pretty significant second year of a decline from a high near $700 million down to about $250 million. There is a theory that most of the industries that had problems have already been sued and those settlements have occurred, and there's not much to sue over. I don't subscribe to that particular theory. I think the theory that I subscribe to is employers are doing a much better job at compliance, and now with Epic Systems, that's driving settlements lower. That being said, 3 days ago, there was a settlement announced in the state of California for a $130 million wage and hour settlement. So those cases are still out there, but I think, again, the trend will be lower declining numbers in 2019. The last trend I wanted to show you was page 29, and that was government enforcement numbers, and that was probably the most dramatic drop that government enforcement litigation had ever seen. It's not much lower than it can go, but I think there's a good chance in 2019 that number dips below $100 million and gets back to historically lower numbers. I also think in 2019 we'll probably finally see the president's complement of nominees to undertake leadership positions at the agencies in Washington finally being approved and being able to carry out their agendas. The last trend, trend 5 that I wanted to end with, was a trend we've never seen before, but a profound trend that I think has been transformative, and that is the Me Too movement. And it started out as one newspaper article in New York City, and I'm sure Braden would agree that the power of one person and one article can have a dramatic impact, and it sure did, in terms of fueling this movement, creating a hashtag for it, and then the impact it's had on corporate boards, executives, the workplace, the litigation process, and last but not least, class actions. I've been working hard with clients over the last 18 months on these issues. I think the best response to the Me Too movement is fundamental, sound, appropriate HR techniques of doing the right thing, having state-of-the-art policies and procedures to respect the dignity of every individual and the value and worth they bring to the workplace, but to be cognizant now that being an employer or being a leader at a company comes with a price tag in terms of being under the microscope of social media, and that anything on the internet can grow and change and find its way into this particular area. What I found was very, very interesting in 2018 for the first time was the use of class action devices to remedy these Me Too problems. The thinking had always been that workplace harassment cases are individualized issues involving an interaction between two people. They don't lend themselves to a class-like solution involving hundreds or thousands of people. But the law responding to that situation, and for the first time seeing pretty significant settlements, the $500 million Michigan State settlement, the $215 million USC settlement, the $90 million 20th Century Fox settlement. There'll be more in 2019, and the use of class action concepts utilized to respond to and deal with the Me Too movement and Me Too litigation. The last slide, page 31, details the Me Too cases brought by the EEOC. Upward arc in terms of those numbers, and I think that what we will see in 2019 are more of those cases, and the EEOC being a vigorous advocate on behalf of those who have been injured in the workplace in terms of workplace harassment. So in terms of 1,453 rulings and a lot of things going on every day, I think those are the important 5 trends and the takeaways.